All right. Well, thank you for coming tonight, everyone. My name is David Lawson. I'm joined by my colleague Beth Bowen from Vanguard Public Affairs, and we are assisting with this town hall meeting tonight with the interim code lead counsels of the class action lawsuit. This first slide is relatively important that if you've already retained an attorney who is not listed below, we suggest that you leave this meeting and contact your attorney directly with any questions that you may have. All the participants will be able to see and hear all of the panelists. We are recording this presentation now, and it will be shared on the flintwaterjustice.com website. If you have any questions, we'll be posing those to the attorneys at the end of the presentation. We ask that you use the question and answer button on the bottom of your screen. And once we close down the presentation, we will then go to the Q&A for those answers. We will also provide written answers as part of the website itself. Okay.
What's that noise?
That is my computer.
No, I'm here.
Okay, so thank you very much for coming tonight to the Flint Water Crisis Interim Class Council Team Town Hall. It is Wednesday, December the 2nd at 6 p.m. Our speakers today include both Michael Pitt and Ted Leopold, the interim code lead counsels of the case. We're also joined by attorneys Teresa Bingman, Leslie Mitchell-Kroger, Trishelle Young, and Cynthia Lindsay. With that, I will turn it over to Mr. Pitt and Mr. Leopold for the presentation. I will mute myself and just ask me when to advance the slides, gentlemen.
Thank you, David. Hi, everybody. Michael Pitt here. I'm interim co-lead counsel with Ted Leopold, and we want to spend some time with you to share with you some of the features of the settlement that was announced a couple weeks ago for the $641 million to resolve the claims on behalf of the people of Flint against the state of Michigan, the city of Flint, and McLaren Regional Medical Center. As you have learned on prior occasions, this is a partial settlement. And what that means is that we will continue as class counsel to pursue claims against V&A and LAN, the two engineering companies whom we assert are culprits in creating the Flint water crisis, and for many of you, claims against the federal government, EPA, for the harm that was caused by the claimants in that case. The most urgent news for today is that we now have a court hearing where Judge Levy is going to conduct a public hearing on the question of whether preliminary approval of the settlement should be granted. That hearing date is December 21. It'll be at 1:30 p.m. Eastern Time. You, members of the public, will be invited to listen in. You will not be able to participate, but you will be able to monitor the proceedings and be able to learn how the process is going to unfold on that date. So we are going to post on our website a link to Judge Levy's courtroom so that each and every one of you can log in and monitor and watch the proceedings. So again, that will be December 21 at 1:30 p.m. That hearing date was set today by Judge Levy. We had a status conference at 2 o'clock this afternoon, and that date has been set. It may change, so watch for news if there's any change in that date. Sometimes courts become occupied with other urgent matters and adjourn matters at the last minute. So we suggest that you check our website to make sure that date is still going. So that's the most urgent news. And Judge Levy also said that she's going to issue a written opinion on the question of whether the settlement should be approved. And if she does that, she told us that she expects that opinion to come out in mid-January of 2021. So we have set our second town hall meeting for January 28th at 6 p.m. We are anticipating that we'll have the court's ruling by that time, and we'll be able to share with you the results of the judge's opinion. So that's the latest news, and we hope that all of you will be able to participate in the next town hall.
Mike,
Yeah.
hi, this is Ted Leopold. I just want to elaborate on one thing you said to make sure there's no miscommunication. What Judge Levy is going to address in December, later this month, is the preliminary approval for the settlement. And as Mike indicated, Judge Levy hopes to get a ruling out about the preliminary approval in early January. And once she issues, if she does issue a preliminary approval of the settlement, then there'll be a long process of then what we say sort of drilling down on the core issues, and there'll be a final hearing many months down the road, probably in May, June, somewhere in that time frame, could be earlier, where Judge Levy will hold an open hearing where the community can come, and she'll have perhaps witnesses, experts, people that she is speaking with, that she is appointing to help her as well, and we'll listen to everybody and then make a decision at that time about a final approval of the settlement. So it's really sort of a two-step process that we'll be going through at that time. So this is just the first step, and hopefully we'll get through this first step well, and she'll be comfortable with at least the preliminary aspect of things so we can then move forward, because the preliminary ruling will then cause a lot of things to happen, such as registration forms and claim forms and things of that sort to happen over the next several months.
All right. So why is the preliminary approval order so important? And as Ted has pointed out, once that order comes out, important dates are triggered in the settlement process. So when the order comes out, you folks will have 60 days in which to submit your registration form indicating you wish to participate in the settlement program. As has been noted, the case involves claims for children who are not part of the class action, and claims for adults for their own personal injuries, property damages, and business losses. And although the children are not part of the class action, they are part of the same settlement program that the adults will participate in. So the children and the adults will be participating in the same settlement program, and many of the procedures of the settlement program will apply to both the children and the adults. How did the settlement come about? Well, as many of you have heard from prior discussions, Judge Levy appointed mediators and a special master to assist the parties in crafting the settlement agreement. The mediators were retired Judge Pamela Harwood and former United States Senator Carl Levin. The special master was Deborah Greenspan. In addition, Judge Levy appointed attorneys who are very familiar with these types of matters to represent the interests of the various subgroups. So the interests of the adults, the property owners, business owners, children of various ages were all represented at the table by separate counsel. And as a result of that process, an allocation between the various groups was arrived at. And, you know, that allocation is 64.5% for children 6 and under, 10% for children between the ages of 6 and 11, 5% for children who are between the ages of 12 and 17, and about 18% was set aside for adults, property damage claims, and business losses. $35 million was set aside for future claims for children who don't immediately participate in the settlement program, and 2% of the settlement was set aside to help with the schools who are responsible for educating the children who have been impacted by the Flint water crisis. These allocations were all debated at length. The mediators, special master, and the special subclass counsel all participated in that process. And after much discussion, these allocations were arrived at. Judge Levy will look very closely at these allocations and will make a decision as to whether or not preliminary approval should be approved. Why are the children getting so much? Well, we all recognize that lead causes injury to the brains of young children. The younger the child is, the more damage the exposure is. And so the science led us to the conclusion that the youngest children should be the subject of the most amount of the money, since they are going to be the most injured in the process. And then there's a scaling down for the children based on age. The children, in our estimation, go first. As we've indicated, there are claims against the engineering companies and the EPA, and we are very optimistic that recoveries for the adults will be enhanced when those additional defendants are brought to the settlement table and they make their fair share contribution to the settlement program.